Good afternoon, everyone, and welcome. I first want to apologize for the technical difficulties we were experiencing a little while ago. We certainly appreciate you sticking with us, and welcome. My name is Gary Rovner. I am the chair of the Environmental Practice Group at Foley & Lardner, and I am delighted to welcome you to today's webinar entitled The Top 10 Things Everyone Should Know About the Upcoming Changes to Prop 65. In this webinar, three of my colleagues will discuss the changes to California's Proposition 65 that are slated to become effective on August 30th of this year. They will also talk about how these changes will impact manufacturers, distributors, and retailers who knowingly or unknowingly sell their consumer products in the California market. Today's presenters are Sarah Slack, Eric Swanholt, and Megan Curran. Sarah divides her time between environmental compliance counseling, transactions, cleanups, redevelopment projects, and environmental litigation. Sarah also provides counsel to clients regarding air emissions, waste management, underground storage tank compliance, water discharge permitting and compliance, and a variety of compliance matters related to chemicals and chemical usage, including under Prop 65. Eric represents manufacturers, distributors, and retailers in product liability, pharmaceutical defects, complex commercial and consumer class action litigation, as well as toxic torts and regulatory litigation. He has defended individual and class action product liability and toxic tort claims in a variety of industries, including consumer products, fashion, pharmaceuticals, off-road vehicles, industrial safety equipment, asbestos, lead paint, and silica. Eric has also represented clients before the Consumer Product Safety Commission in connection with investigations and recalls. Megan provides strategic guidance to clients in a wide range of business and compliance matters. This includes assisting clients with risk management and environmental regulatory compliance. And with regard to such compliance, Megan has in-depth knowledge of California's environmental regulations, including Prop 65. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. We encourage you to submit written questions during the program. Please type your question into the Q&A widget that you see on your screen. We will respond to as many written questions as we can at the end of the program, time permitting. This PowerPoint presentation will be available for downloading on the resource list widget. The presentation, along with a recording of the webinar, will be available on our website at www.foley.com within the next few days. And lastly, if you are seeking CLE credit today, please enter the code that will be announced later on in the program when prompted. With that, I would now like to turn the presentation over to Megan Curran.
Thank you very much, Gary, and thank you all very much for joining us today. We look forward to an interesting and informative discussion of the changes that are upcoming to Prop 65. As you may know, the Prop 65 regulations regarding warnings are changing, as Gary mentioned, effective August 30th of 2018. We recognize that some of you may be experts in Prop 65, but we also recognize that some of you may have only heard the name Prop 65. So we want to try to give you some background regarding Prop 65, and then we're going to go into the 10 things everyone should know, which is obviously the title of the presentation today. The 10 things that we're going to talk about, and I'll just go over them quickly, and obviously we will go over them in depth throughout the presentation. The first thing is that some things have not changed with respect to Prop 65. The second point that we'll discuss is that some things have arguably changed or have been formalized with the new regulations. Then we will go into consumer product warning language. There's something called a long form. And then the next topic will be consumer product warning language in the short form. The fifth topic that we will discuss is consumer product warnings over the Internet. And the sixth topic will be consumer product warnings in catalogs. The seventh topic will be the responsibility to provide consumer product warnings, namely who has that responsibility. The eighth topic is about a company's ability to supplement the suggested or safe harbor warning text. The ninth topic will be specific types of warnings for specific types of industries and locations. And the last of the 10 topics will be compliance and timelines. And then the final substantive discussion today will be practical considerations in light of everything that we discussed earlier in this presentation. So as I mentioned, we want to just give you a little bit of background to make sure that everybody knows kind of the lay of the land for Prop 65. So the first substantive slide here is, what is Prop 65? In 1986, California voters passed Prop 65, and Prop 65 requires businesses to provide consumers a clear and reasonable warning before knowingly and intentionally exposing consumers to certain listed chemicals. And obviously our presentation today will go through a number of the key elements of that overarching topic, but we've also included some pictures here, which hopefully you can see on your PowerPoint. If you've ever visited California, you've probably seen these warnings. The first picture is a warning on a consumer product, and this is the currently applicable language to Prop 65. This language will not be will not be within the safe harbor starting on August 30th, 2018. The second warning that you'll see here is a warning for a food establishment. And then the third warning is an occupational or environmental warning. Obviously, as you can see, it's in Spanish. And as we will discuss on some subsequent slides, there are requirements regarding providing the warning that we will discuss in other languages under certain circumstances, depending on what the rest of your product label looks like. One thing that we will talk about is there is a requirement to, I guess most of this presentation today will be discussing the requirement to provide warnings. I think it's important to note in the background that one option is also to reformulate products so that the chemicals that are present in products are eliminated. So while we will be discussing warnings today, it should be noted that a company or an entity always has the option to reformulate a product so that the chemicals are no longer present, and then, obviously wouldn't, assuming that the chemicals are gone, wouldn't have or are below the levels that are required, would not have an obligation to warn any longer. So that's just something to think of in the back of your mind. So this slide is about what warnings currently look like under Prop 65. And by currently, I mean these are the regulations that will be applicable until August 30th, 2018. Warnings must be clear and reasonable, and the warning language varies based on whether the chemicals at issue in the product present a risk of cancer or reproductive harm. Those are the two quote-unquote endpoints, either cancer or reproductive harm. And this picture here is of the current generally accepted warning for consumer products. Obviously, this sample is for both endpoints, allegedly causing cancer and birth defects or other reproductive harm. So this is likely the Prop 65 warning that you have seen, to the extent you've seen any Prop 65 warnings. So just starting at the highest level, the first step in a Prop 65 analysis is to determine what chemicals are present in either your products or in the environment or in workplaces, because those are the three warning schemes. It's either product warnings, environmental warnings, or occupational warnings. Once you know what chemicals are present, you can compare those chemicals against California's list of chemicals. And as is noted on the slide here, there are over 900 chemicals currently listed, and certain chemicals have been listed and then delisted, so it's important to review the list. And the regulations require that the governor revise and republish the list at least once per year. So as I mentioned, the list changes, obviously, and some of these changes are additions. And in order to add a chemical to the list, there is a set process. The first step is there's a public notice that goes out that a chemical is under consideration for listing. The second step is a public comment period. The third step is a review of the comments received regarding the proposed listing of that chemical. And then the fourth is the notice of final decision. And it's important to note that once a chemical is listed, it's generally not effective or able to be enforced under Prop 65 for 1 year. And that's obviously important for businesses who are looking to comply with Prop 65 because if a chemical is listed, there will be some time that is necessary to implement the changes that apply with respect to that chemical. So if a chemical is added, as I said, there'll be a 1-year compliance gap or lag, I guess you could say. That gives companies time to contemplate the addition of that chemical, possibly test products that the company suspects may have that chemical, or check records regarding testing of their products, and take the necessary steps to warn or reformulate the product if desired. And as I mentioned, there will be a year to accomplish all of those steps. And if you're interested in what this list of chemicals is, there's a link right there on the end of that PowerPoint slide that contains the list that was updated as of December 27th, 2017. So once you've determined which chemicals are in your products or in the environment or in your occupational workspace, you will want to reference the levels of chemicals that you're experiencing or that are present. California has established safe harbor levels for many chemicals on the Prop 65 list. And the safe harbor levels, there's a small snippet of the chart there on the PowerPoint slide just so that you can see what it looks like. For carcinogens, meaning cancer-causing chemicals, there is a no significant risk level. And for chemicals that cause reproductive toxicity, there is a maximum allowable dose level. So to the extent, theoretically, to the extent that a chemical is carcinogenic, there may be a no significant risk level set, and to the extent that a chemical causes reproductive toxicity, there may be a maximum allowable dose level set. So it's advisable, once you know the chemicals, to determine whether California believes that those chemicals are carcinogenic or cause reproductive toxicity, and then to evaluate what the levels are in your product to see whether there is an arguable case for exposure of California consumers above the either no significant risk level or maximum allowable dose level. And it's worth noting, too, that there are some chemicals where enforcement actions, meaning consent judgments or in-court settlements, have resulted in standardized exposure levels relative to certain types of products. So it is worth looking into whether the chemicals at issue in your products have some standardized amount that the industry generally accepts as acceptable for that product or that chemical. Okay, so we're just going to do a quick coverage of what a Prop 65 case looks like, just to give you some background on this. So the first step in a Prop 65 piece of litigation is receipt of a 60-day notice. So the 60-day notice notifies a company that a plaintiff alleges that there is a violation of Prop 65. 60-day notices must be supported by a certificate of merit, which basically says that plaintiff's counsel has consulted an expert who has certified that the exposure presented exceeds the levels permitted by Prop 65. And the purpose of a 60-day notice is to let the state AGs or state offices intervene in cases if they so choose. Assuming that no state agency intervenes in that 60 days, a plaintiff is free to file a lawsuit after that 60-day notice. So in terms of the process of dealing with a 60-day notice, once you receive it, to the extent it's sent to you, it makes sense to send that to counsel to start getting legal advice about how to go forward. And the first thing your counsel might want to do with you is review the sales figures for the noticed product and other similar products for 1 year prior to the 60-day notice. That is the generally accepted Statute of limitation, there is also an argument that can be made that the statute of limitation is actually 3 years, so that may be an issue that needs to be discussed between your counsel and plaintiff's counsel. The next step may be exploring settlement, if that's something that your company is interested in. There are 2 general settlement realms. There's either an in-court settlement or an out-of-court settlement. And out-of-court settlements obviously are what they sound like. Generally, no litigation. Well, I guess by definition, no litigation will be filed, and you settle your case out of court before that litigation is filed. You can also settle your case in court after the litigation is filed, and that will result in a consent judgment. Some companies prefer to have an in-court settlement because it provides certain preclusive effects against other plaintiffs' counsels or plaintiffs suing the company based on that product. Some cases don't settle at all. Some cases, or settle later in the litigation process. Some cases might fight out whether the exposure exceeds the NSRL or the MADL levels that we discussed. And other cases are obviously litigated through trial. So that's the general life of a Prop 65 case. So this slide is just meant to point out that Prop 65 cases can be costly and often are. We've included on this slide some settlement figures. First, for in-court settlement figures, in 2016, there were 760 reported settlements with over $30 million in total settlement payments, ranging from $3,000 on the very, very low end to over $650,000 on the high end. 72% of that settlement value went to plaintiffs' attorneys' fees and costs. The average in-court settlement based on those figures in 2016 was $39,671. In terms of out-of-court settlements in 2016, there were 339 settlements with a total of a little over $10 million, and the settlements ranged from $3,000 on the low end to $500,000 on the high end. Similarly to the in-court settlements, 77% of the total settlement value went to plaintiffs' attorneys' fees and costs, and the average settlement out of court in 2016 was $29,903. And it's worth also noting here that these figures do not include attorney's fees. So, one must think that on top of these settlement values, even if you're taking the average, there will be some portion of attorney's fees for your attorney to deal with these cases on your behalf. And then another thing that's worth noting as well is that there may be press associated with a 60-day notice and even a settlement of a Prop 65 case. All 60-day notices are public. There's a public website where you can search 60-day notices, and the settlements are also available, whether that's in court or out of court. Those are also available online. So, and I can say from experience, not personal experience, but just from reading the news, that higher profile cases under Prop 65 are at least occasionally picked up by local or regional news. So obviously there can be costs to your business other than monetary costs with respect to a Prop 65 case. So the last background slide is just kind of setting the scene for why we wanted to talk to you about this today. So in August of 2016, August 30th, 2016, there was an adoption of amendments to basically the warning requirements of Prop 65. The new regulations are intended to improve the quality of the warnings being given while providing compliance assistance to businesses subject to the warning requirements. These new regulations will take effect 2 years after the adoption, so August 30th, 2018. And between now and 2018, businesses can comply either with the quote-unquote old Prop 65 requirements. Some of those examples were what I showed you on the earlier slides, or the new requirements, which is what we're going to talk about today. So you probably all came to hear the top 10 things to think about with the new requirements, so I'll turn it over to Sarah to talk about the first few of the upcoming changes.
Thank you, Megan. Good morning, good afternoon, everyone. My name is Sarah Slack, and as Megan indicated, I am going to start us down the path of the top 10 things that everybody needs to know about the changes that are coming up. So the first thing we thought that it was important to just talk about is that there are a number of things that have not changed. So really, under the revisions that were put into place in 2016 and that go into effect in August of this year, the real crux of the changes that will impact the regulated community are to Article 6, which is the clear and reasonable warnings element of the Prop 65 regulations. As Megan indicated, there are and will continue to be 3 general areas of exposure, either through possible consumer products, environmental exposures, and occupational exposures. Another thing that is not changing is that there are still going to be the 2 quote-unquote endpoints. So it will still be cancer and or reproductive harm. So those are things that are not changing. A couple of other things that are not changing is, arguably the duty to warn remains very similar to what it was previously. There are some new language requirements that we're going to be discussing shortly, as well as some additional places and types of warnings that are required to be provided. But in general, the duty to warn is pretty similar. Also, the list of chemicals, so Megan talked about the list of chemicals under Prop 65, which should be any business's starting point for Prop 65 compliance. That was not changed by the 2016 amendments. I do note, as Megan indicated, that is updated regularly. There were chemicals that have been added over the course of the last several years, but that was just through the regular listing process, which also was not changed by these amendments. Nor were there any changes to the mechanism for providing the safe harbor levels or for those safe harbor levels. There were no changes also to the general 60-day notice process that Megan went through with respect to enforcement under Prop 65. And so, so that's where we note that there are, the more things change, the more they stay the same. And so we just wanted to note that there are a number of areas where there will be no changes going into effect in August. So that being said, we did want to talk about some areas where we see that things have been updated or are arguably being formalized. So under the existing regulations, so those regulations that are in effect now through August of 2018, there are already existing warnings that are required for food and alcoholic beverages. We note that there are updates to those warning requirements that are generally consistent with the changes that we'll be discussing with respect to some of the long and the short form warnings. But that those are just generally updates. There was already warning language that was required and in place for those types of products. And then in addition, there are some requirements that we perceive have really been formalized. So these are places where a number of parties were already providing some type of warning or were, and so it's not that they were not previously required, but now under the revised regulations, there is going to be specific requirements for these types of warnings and also specific language that is being provided for safe harbor. So for example, online and catalog sales, arguably prior to these changes, there were a number of parties who were providing those types of warnings, but now under the revisions, and Eric's going to be talking about these, there are a number of very specific requirements. Similarly for some certain specific products exposures such as furniture, also in specific environments, enclosed parking lots. This is an area where if you've been in a parking lot in California, you've probably already seen a warning, but now there's a specific safe harbor language that's being provided under the regulations. And then finally, one thing, and Megan touched on this also, is that providing warnings in languages other than English. This is something that a number of parties had already been doing to the extent that they were providing warnings on either labels or in places where signage was also posted in languages other than English, but that has been formalized under the revisions here. So then getting to some of the consumer product warnings before we get to the specifics of the long versus the short form warning. There are a couple of things that we wanted to touch on. First of all, the warnings have to still be prominently displayed on a label or sign. The general provision that the label or sign has to be noticeable enough as compared to other labeling so as to be likely to be read and understood by an ordinary individual under customary conditions of purchase or use. So again, you're still required to provide that notice in advance of the purchase or use. With respect to the warning in the vicinity of the product, it's got to be, if you're posting a sign or a shelf tag or a shelf sign, it's got to be located at each point of display of a product. So if you have multiple displays, then you just need to be aware of making sure that the warning is posted with whatever that product may be that has the listed chemical. So one of the big changes that is now going to be required is that for both the long and short form warning, you're required to provide a link to a website, www.p65warnings.ca.gov. And that is a website that takes consumers to, or folks that are exposed to environmental exposures, to a website managed by the state that just talks about what Proposition 65 is, what the warnings mean, and provides additional information with respect to them. And then, as I indicated earlier, another change is that to the extent that there are signs in an area, or if your label contains a language other than English, then you're also required to provide the warning in that language. So, if it's in a restaurant, or again, if it's on a product, just making sure that you're aware of what other language may be on a label or on a sign, and making sure to provide the Prop 65 warnings in those other languages too. So then getting into some of the more specifics. So under the revisions, there are two types of warnings that are available to be provided for consumer products. The first is the long form. One other thing to note first off here is that a warning symbol is required. That is, and I have an example of that on the next slide, but it's going to be a yellow triangle with an exclamation point in it in the middle. There are provisions under the regulations where if the entirety of your label or your sign is in black and white, then you can provide that in black and white as well. However, to the extent that color is available or is used, that it is required to be yellow. For the long form warning, the requirement is that you are required to list one or more of the listed chemicals have to be included in the text of the warning. And this is a big change. Now, as Megan indicated previously, the language was fairly generic, and that it just required a warning that a product contained a chemical that is known to the state of California to cause cancer and or reproductive harm. That is no longer sufficient for the long form under the new regulations. A specific name of a chemical is required to be listed. And the way that the regulations work is that you're required to list one chemical for cancer and one for reproductive toxicity if you're providing both of those warnings, unless or to the extent that you have a single chemical that may be present which causes both. So if you have a chemical that causes cancer, you can provide the cancer warning. If you have a chemical that is known to the state of California to cause reproductive harm, then you can use that chemical for that warning. Or if you have a single chemical that is listed for both, then you can provide just a single warning. And just by way of example, there are a number of chemicals that are listed on the list as being known to the state of California to cause both cancer and reproductive harm. Those include, and this is just an example of some of the most common, acrylamide, benzene, chloroform, hexachlorobenzene, lead, methyl chloride, polybrominated biphenyls, chlorinated biphenyls, and then also I believe certain other chemicals are also listed for more than one. So then just moving here to the next slide, this is an example of what the consumer product warning in the long form will be required to look like. Again, you see the yellow triangle with the exclamation point in it, the capitalized all caps warning, and then this is an example here which provides that it would have two different chemicals listed, one for cancer, one for birth defects or other reproductive harm. And again, the requirement at the end that there is a link to or for more information to go to the website at p65warnings.ca.gov. The long form warning can be provided on either a label or on a sign. And that is something that is going to be distinct from the short form warning that we're going to talk about next. So the revised regulations also provide for a short form warning, which has a number of benefits, including that it is briefer, it's shorter, and also that it does not require an explicit reference to a chemical or chemicals. Now, this is only available on products. That being said, and not to steal too much of Eric's thunder, if you provide a short form warning on your label, you may also provide that warning on the internet. But again, it's only generally required on the label, so it's not available for signs. So that would include that it would not generally be available for environmental exposures. And basically it can be on the product itself or its immediate container or wrapper. So for example, you have something that's shrink wrapped, it could still be on that. The idea here is that OEHHA was trying to provide for a short form that folks could put on a smaller product. That being said, there is no prohibition or exclusion that requires that the short form not be on larger products. So it certainly can be used on larger products. And here is an example. So you'll see, obviously, the language here is much more brief, and it takes up a lot less space. It's got the warning symbol still, and then this would be an example for a product that contains a chemical known to the state of California to cause both cancer and reproductive harm, and then it provides a link to the website. So again, it's a much shorter form, and we expect that it will be used on a number of products. And with that, I'm going to turn it over to Eric, and Eric's going to continue on our journey through the top 10 things. Eric?
Thank you, Sarah, and hello, everybody. Thank you for joining us. It's a pleasure to speak with you all. As a reminder, I'm a trial lawyer and litigator in Los Angeles, defending companies just like yours, mostly against consumer class actions, product liability matters, and Proposition 65 cases. I'm going to talk about a new twist to these regulations, which is more specific requirements with respect to internet warnings. Most companies now sell products over the internet in some form or fashion. Previously, to be compliant with Prop 65, companies often had a single warning, perhaps at the bottom of their homepage, that provided general language consistent with the safe harbor language provided by the statute. And in fact, over the years, we've seen very few internet warning-related Prop 65 notices of violation or lawsuits. It just hasn't been a focus to date of the plaintiff's bar. But given these new requirements and the specifics of them, which we'll discuss, we may see an uptick in that focus by the plaintiff's bar. The internet warnings and the catalog warnings, because they are new and so different from the prior iteration, the regulator has propounded or provided an FAQ that you can review at p65warnings.ca.gov. P as in Paul, like Prop 65, p65warnings.ca.gov. And there it answers a lot of questions that you might have with respect to how to comply with the provisions going forward. The revisions are under 27 CCR 25602 subsection B, and the big difference is that the new warnings are required to be clearly associated with each product that falls under the provision. So each product that contains a listed chemical that exceeds any allowable threshold must have a compliant warning clearly associated with it on the internet page. It must be prominently displayed in a location. You can't require your consumer to search for it. There are a number of ways to provide that warning. You can use a hyperlink and use a full warning, or if the product comes with a short form warning, you can use the short form warning. Another option is if the product has the warning on the product itself or on the box, you can take a picture of the warning and provide a link to the picture. So long as that link is provided on the same page as the product, you will be compliant. Another option that some internet retailers are using is that when you get to your shopping cart and you type in your zip code, indicating to the website that the products will be shipped to California, a pop-up can happen then if the zip code is a California zip code, which will provide the warnings for whatever products in your cart require them. That can be an effective way to comply. The general warnings of the past are no longer allowed. Any requirement that the consumer conduct a search to find Prop 65 warnings are no longer allowed. And one question that comes up often is, when the business is not in California, it's an out-of-state business, an out-of-state internet retailer, but products are sold into California, is it required to comply? And I don't think any of us are surprised to learn that it is. If you sell products that cause exposure to listed chemicals in the state of California, you need to comply with Prop 65. Now, the issue coming up is how to do this when you're a company that sells volumes and volumes of products over the internet, and you're a retailer and not necessarily a manufacturer, and you may have questions about whether or not certain products require warnings. There's a number of ways to sort of get to that. I'll talk to in a moment about how that burden is shifted to the manufacturers rather than retailers, but we have ways to help ensure or help improve compliance with this challenging new provision. The same rules have been applied now to catalog purchases as well. Before, in the olden days of actually today and yesterday, you could comply by providing a general warning, usually at the back or in the order form, that said some products may cause, and that's no longer effective. Again, in the catalog context, which is 25 CFR 25602C, subsection C, the warning must again be clearly associated with the item being purchased. The point of these really is because when you go into a brick and mortar store and you're looking at a product, you can clearly see the warning before you buy it. What the new regulations are meant to prevent is a consumer buying a product over the internet without having first understood that it does contain a chemical that's on the list. There's a lot of pushback on this, saying that the consumer would get the package in the mail and the warning would be on the package, and the consumer could then return the product before use, before actual exposure, because the warning would be on the outside, on the box or on a label. And the conclusion was that was ineffective and put too much burden on the consumer. So the regulation now requires that clearly associated link on the internet page or on the catalog page, so the consumer can make a fully informed decision before purchase. I have not been clicking through the pages there. Another significant change to the provisions is who must provide the warning in the first instance. The prior iteration of the statute was broad enough to place a burden on everybody in the supply chain. The purpose of one of the purposes of these revisions is, and this is stated in 25249.11, is to minimize the burden on retail sellers of consumer products regarding the clear and reasonable warnings. There are certain exceptions to that. But the point is, and I've seen some of these questions pop up in the Q&A, oftentimes the retailer has no idea or no control of the chemicals in the products, and so is at a disadvantage or sometimes completely incapable of determining whether or not a product ought to have a warning. And so the statute now shifts the burden to manufacturers, to manufacturers, producers, packagers, importers, suppliers, or distributors of a product. That's under 25600.2. If you look at that provision, a manufacturer can comply with the article by either putting the label on the product itself, bearing the warning that satisfies the statute, or can provide written notice to the retailer that explains that the product may result in an exposure to one or more of the listed chemicals, that includes the exact name or description of the product, including maybe a UPC code or some identifying information. That includes all the necessary warning materials, such as labels, labeling, shelf signs, or tags, and warning language if a product is going to be sold over the internet, so typically all of those items. And then the manufacturer or producer must obtain written confirmation, it could be electronic, that the retailer has received that information. And now this is the way a retailer can obtain information from manufacturers or suppliers regarding warnings by sending a letter or a certificate of compliance asking the manufacturer to provide the information. And if the product does require a warning, then the manufacturer has the obligation to provide that information. And once that information is provided, then the burden shifts to the retailer for placement and maintenance of those warnings. If the retailer receives the shelf signs, they have to put them up. And if the package comes with a warning on it, the retailer cannot obscure the warning by the way it stacks the boxes in the store. The purpose of this, again, is to protect retailers from being obligated to comply with a rule that it does not have the information necessary to comply with. The warnings provided by the manufacturers to the retailers need to be updated annually, and or when new chemicals are added to the product, or when new products are added to the chemical list. So the manufacturer has to be diligent and vigilant in making sure its retailers are kept apprised of the current status of the product configuration, the chemical, the MSDS, et cetera, so that the retailer can comply with the statute. An interesting component to this, I think, is that the burden can shift to the retailer when, again, if the retailer takes its own action to either sell the product under its own trademark or brand name, if the retailer changes the chemical composition of the product by introducing a known listed chemical or by introducing a non-listed chemical that somehow alters the state of other chemicals in the product that cause them to no longer comply. And the number 5 there on the page, I think, is an interesting one, because there are times when a retailer, when a manufacturer is not obligated to comply with Prop 65, maybe it has fewer than 10 employees, for example, the burden to warn can shift to the retailer if it has actual knowledge that the product contains chemicals that exceed the listed threshold. Actual knowledge is defined in the statute under 25600.2F, and it is, I think, ripe for some litigation down the road, perhaps. Actual knowledge is defined as specific knowledge of the consumer product exposure received from any reliable source, and reliable source is not defined. And so it will be interesting to see how that is implemented going forward. One note from that provision is that there is a safe harbor of sorts. It says that if the notice of a consumer product exposure is provided by a private litigant, so one of these plaintiffs' firms that sue under Prop 65, the actual knowledge will not be deemed to have occurred or arisen for the retailer until 5 business days have passed. And so if a retailer receives notice that one of the chemicals it's selling without warnings contains chemicals that exceed, listed chemicals that exceed the threshold levels allowed, it can, it has 5 business days to add a warning, either to its internet page or to the shelf, to potentially cure any violation. That is another area that has not been litigated, and I'll be curious to see where it goes. But that does look like a safe harbor to us. The new provisions also provide an opportunity for manufacturers to provide supplemental information to the warnings required by the statute. And I saw one of the questions in the Q&A had asked about First Amendment challenges, and this is along those lines. There had been complaints that the regulation was too strict, that the language required too narrow, and that it did not allow manufacturers to provide context or an explanation for the use of the chemical, for the effect of the chemical, or the source of the exposure. And there have been challenges under the First Amendment and other statutes to Prop 65 and it's in the Office of Environmental Health Hazard Assessments with respect to certain listed chemicals. We'd be happy to share some cites to some of those cases that are pending in various appellate courts. I'm not aware at the moment of broad challenges to the statute as a whole, but as to certain specific chemicals where there is a dispute as to whether the chemical should be listed at all, there are pending challenges under the First Amendment under any kind of limitation where a manufacturer is not able to provide context or communicate with its consumers, it could face First Amendment challenges, and we've seen that. I think the goal of the supplemental warning provision here, which is at 25601E, subsection E, is to compromise between the sort of rigor of the statute and its goals to provide clear and reasonable warnings that every consumer can understand, and the First Amendment right of a manufacturer to communicate with its consumers and describe its product in a way that it desires, so long as that description is truthful. There is a 273-page statement of reasons provided by the OAG for these amendments, and this discussion is held in there, along with the discussion of a lot of the other amendments, the bases for them, and the comments received by the public. It is available on the website if you're so inclined. As Sarah mentioned earlier, these revisions provide a little bit more specificity with respect to certain types of warnings. They're called tailored warnings for various products. And I think when you see the warnings, and you've seen them in various locations, you'll understand the need for these types of warnings. If you're eating food, it would say, consuming this product may cause or may expose you to chemicals that the state of California, et cetera, or drinking distilled spirits, can cause these types of issues. And so the statute provides a long list of provisions that specifically apply to each of the various product-specific issues or categories, as well as certain location-specific regulations. It actually takes up more than 50% of the entire regulation, this particular portion, which is at 25607 through 25607.31. So it's a little too lengthy for us to go into in any kind of detail here, but we'd be happy to address or respond to any questions about specific products. A lot of these are also provided because the packaging, for example, may be too small or may be non-existent. And so there are a number of ways that the regulation provides direction to companies that sell these products or control these types of listed locations so that they can comply with the applicable regs. The good news is that if you do not currently comply with the new amended regulations, you have time to do so. They do not become effective. They will not be enforced until August 31 of this year. The regulations do allow you to comply with the new regs now. So if your warnings are compliant with the amended regs, you will not be deemed to be non-compliant with the soon-to-be expired regs. The regs apply only to products manufactured after August 30th, 2018. But again, we believe best practice is to begin implementation of these new warnings sooner rather than later. And a lot of times, of course, it takes time to get these warnings in place or developed, or to, if you're a retailer, to get information from your manufacturers and suppliers letting you know whether or not you need to provide warnings. another piece of good news is that if you have previously settled through a court-ordered settlement, Prop 65 litigation, and that settlement includes a judgment that the warnings you are currently providing are clear and reasonable and comply with the statute, with the reg, then you do not need to change your warning to comply with the new regs. The court order that you have will be grandfathered in. It's under 25600 subsection E, and so that will preclude the need to amend your warnings to comply with the new regs going forward. One thing I'll note is that as we've seen over the years with the Prop 65 litigation, many of these cases are settled and some are settled fairly readily, and there is a balancing question about whether or not the cost of defense is worth the settlement value. Sometimes it costs less to settle than it does to fight. And that is a business decision. But it is worth noting that there are defenses to Prop 65 lawsuits that can be effective, particularly in dealing with some of the repeat plaintiff firms that are out there. There are firms that file dozens, if not hundreds, of notices of violation a year. It is part of their business model. And if you become known to them as a company that will contest those notices of violation when it's appropriate to do so, it may deter them from bringing perhaps less meritorious claims. And there are a number of types of defenses. Just a couple that come up regularly are when a new chemical is listed, as Megan indicated, a company has a year to provide warnings or reformulate. Oftentimes, the notices of violation come in too soon. And so if a year has not yet passed and you receive the notice of violation that your product does not comply, you have a defense. Another standard attack is that a notice of violation will indicate that a product that the product itself has a chemical concentration exceeding the minimal exposure level, but it does not say that the exposure to that chemical exceeds the level. And there's a difference between what the chemical concentration in a product and the exposure level. And the exposure level can be impacted by a number of things, including the type of product, the expected use, the length of use, the concentration of the chemical, how a chemical exposure occurs, et cetera. And so while that may take a little bit more effort to defend, including potentially expert reports, it is a fair and strong defense that can often serve to eliminate or reduce exposure in a notice of violation or a Prop 65 case. With that, I'll turn it back over to Sarah, and thank you very much for your attention.
Great. I think actually next, Kayla, are you going to provide the CLE code?
Yes, thanks, Sarah. I will quickly announce the CLE code for anyone requesting credit today. That code I will share briefly, and you can type it in the box below. That is MEIHG. Again, that's MEIHG. One more time, that's M as in Mary, E as in elephant, I as in igloo, H as in ham, and G as in girl. I'll leave this box open briefly. For those of you that are seeking New York credit today, please fill out the attorney information form noted on the resource list widget in addition to submitting the poll question. You can send that to me at khooven@foley.com. My contact information is in the slides. And as a reminder, certificates of attendance for today's program will be distributed approximately 6 to 8 weeks from now. And at this time, the poll is now closed. Thank you.
Thanks, Kayla. So then just to finish up, we thought that it would be helpful to discuss some practical considerations in light of these changes to the Prop 65 regulatory scheme. So first of all is just understanding your company's role in the production, distribution / retail scheme. There has, as Eric indicated, been a shift towards putting more of the onus on the upstream folks. So that's going to be, the manufacturers, the distributors, the importers, the producers, the packagers, then on the retail entities. And so just understanding where you fall within that scheme and what your potential liabilities are and what your potential tools that you may have to try to get information with respect to what types of Prop 65 chemicals may be in products. So, those tools range from reviewing information on SDS forms to see what may be there. And again, I'm not saying that it's appropriate to use an SDS to provide a Prop 65 warning. I'm just saying if you are a downstream entity and you're trying to review where you may be able to find some of this information, that's one way to look. The other thing to do is to actually coordinate directly with your, with the upstream providers, either by sending certifications or request letters. We certainly have a number of clients who we're working with on those types of projects, and just understanding what your potential responsibility is. The other thing to do is to evaluate what information is available and the cost of obtaining additional information. Again, ultimately the responsibility or the duty to warn is going to be on the entity that has the information. So generally it's going to be those upstream entities. And what tools may be available both to them and to the downstream users to evaluate that. So those tools include, as I indicated, reviewing SDS information, looking at product certifications, and then, also in certain circumstances it may be appropriate to conduct some limited testing of products to determine whether or not there may be Prop 65 listed chemicals in them. And so I think that those are the main things. Eric and Megan, did you guys have anything to add to that?
Yeah, this is Eric. The one, for folks who want to learn more about this as well, there's a great organization that, I'm speaking for Eric only here. I don't know that I don't want to sponsor an organization that maybe others don't agree with, but the International Consumer Product Health and Safety Organization, the KIPSO, ICPHSO, is a neutral forum for product safety stakeholders to learn and network and share information. The CPSC and a number of regulatory bodies often attend conferences and provide educational materials, and it's a great place to work with other manufacturers or providers of consumer products, as well as experts in the field, testing labs, and others who are all interested in product safety in the first instance, and then obviously reducing exposure to liability or penalties in the second instance. And so I recommend it. I'm a member. I have been for a while, and find the meetings and the information to be quite useful.
All right, and then, obviously to the extent that I know that we have a number of questions, and to the extent that we aren't able to get to those today during the call, I think as Kayla indicated, or perhaps Gary at the beginning, we will endeavor to respond to those to the individuals who ask them. We have the information to be able to do that. So I think that is the end of the presentation. And thank you everyone for joining us today.